Hello, welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gaff. I'm a senior member of the IEEE and partner at the Edwards Wildman Palmer law firm in Boston. The IEEE is presenting this podcast in conjunction with a column that I co-author that appears each month in the IEEE's Computer Society Computer Magazine. That column discusses legal issues relevant to people in the computer hardware, software, networking, and service businesses. In the last podcast, we discussed the Foreign Corrupt Practices Act. In this podcast, we will discuss some issues regarding design patents that we covered in our March 2013 column in Computer Magazine. Joining me today for this podcast is my colleague, Pete Cuomo. Pete is an associate in the Boston office of Edwards Wildman Palmer. Welcome, Pete.
Thanks, Brian.
Pete, design patents are getting increased attention today, possibly due in part to the $1 billion in damages awarded to Apple in its infringement lawsuit against Samsung. That amount took into account the infringement of both design patents as well as the more commonly known utility patents. For the benefit of our listeners, can you describe some of the differences between design and utility patents?
Sure. A design patent protects just what it says, an article's design or visual appearance. The subject matter of a design patent application may relate to the shape of an article, the surface features or ornamentation of an article, or a combination of the two. An example of a protected design would be the popular Crocs shoe. Another example might be the shape of a teapot that you have in your home. By contrast, a utility patent protects the way a product works or its functional features. Any new and useful method, process, machine, device, or chemical compound can be covered by a utility patent. The prescription medicine you take each morning, or the razor or hairdryer you use to get ready in the morning are likely covered by a utility patent. Another feature is that design patents tend to be shorter since they do not have the complex written description of a utility patent. Design patents also tend to be less expensive to prosecute due to their relative simplicity, and unlike utility patents, they do not require any maintenance fees. Design patents also have a shorter term of 14 years versus 20 years for utility patents. But it's worth noting that the terms are measured differently. The 14-year term of a design patent is measured from the date of issuance, whereas the 20-year utility term is measured from the date of the application or an earlier date if the patentee claims priority to an earlier application or patent. So the term difference may not be as large as one might expect.
Okay. How about damages in an infringement case, like the $1 billion in the Apple-Samsung case? How are those calculated? And are the methods the same for design and utility patents?
Well, with a utility patent infringement, generally with utility patent infringement, a patentee can recover damages in the form of lost profits or a reasonable royalty. The reasonable royalty being some percentage applied to the sale price of the article. Design patentees can recover those forms of damages, but they also have an additional statutory remedy that allows them to recover an infringer's total profits for the design infringement. So design patent owners have the choice to pursue the traditional remedies or to try to recover total profits, although courts have imposed some restrictions on the latter.
Let's talk about the process for filing an application for a design patent. What is that process? Could you outline it for us?
Sure. In the United States, a design patent is filed by drafting a single claim that states, quote, the ornamental design for a X, substantially as shown and described, where X is the article or the subject of your design patent. The design patent will also include drawings that correspond to the shown and described language, and these drawings are extremely important because that is what is actually being claimed. So the drawings must be prepared carefully to ensure that they are true and accurate. Also in the drawings, you'll see solid lines and dashed lines. The solid lines depict what is being claimed, whereas the dashed lines are the unclaimed subject matter.
So if you're looking at a patent, a design patent, and you're trying to determine whether there might be infringement or maybe just trying to figure out exactly what the patent covers, naturally going to have to look at the drawings very carefully. And when you look at those drawings, as you said, you'll see part of them are drawn using solid lines and other parts of them are drawn using dashed lines. And the message there is that only the parts of the figure that are shown in the solid lines are what the patent covers. The parts that are shown in the dashed lines do not relate to what the patent covers. They basically show a context or a background. Is that another way to think about it?
Sure, that's correct. The dashed lines are the unclaimed portion of the article and generally are used to supply the context for the claimed portion, which is shown with the solid line. So if you were trying to assess the scope of the design patent, you would have to focus on the solid lines that are shown in the drawings. And the dashed lines would just help to provide the background or the context of what is being claimed.
So obviously a big mistake in the drafting of a drawing for a design patent would be to inadvertently put something in with a dashed line when you actually meant to claim it, because if an analysis were being done or litigation resulted, its appearance in a dashed line might lead to an absence of coverage of what you had versus what you had really expected, right?
Right. Yeah. Yes. A dashed line would basically be non-covered subject matter. So if you were trying to claim that, you would have some problems during an infringement proceeding.
Okay, thank you. Now, what about international filings? That is, instances where you might want to file a design patent application not just in the U.S. but in other countries at the same time. For utility patents, applicants have long had the option to file international applications under the so-called Patent Cooperation Treaty, or PCT. Do applicants for design patents have the same option?
In a sense, yes. There was a Patent Law Treaties Implementation Act of 2012, which was signed by President Obama last December, and it establishes a procedure to file a single international design application with the USPTO and then designate contracting parties to the Hague Convention Treaty. So an applicant could go ahead and file one of these international design applications and then designate the contracting countries that the applicant would like the patent to be prosecuted in. So it's a uniform way to file a single application, but that application will go not just to the USPTO but to international patent offices as well. Some other interesting aspects of that Patent Law Treaties Implementation Act: it will also allow applicants to claim priority to or from an international design application, and it will extend the term of design patents in the U.S. from 14 to 15 years beginning next December when the Act goes into effect.
Well, that's very interesting because for the benefit of our listeners who might not be familiar with international patent filings, it's a mechanism by which an individual can file a single patent application in a specific international-like form, and after a period of time and processing, then can file that application or refile that application in specific countries, or so-called contracting parties, as you mentioned, where the countries have agreed to abide and follow international application procedures. So for the most part, one can simply file one document or one application and reuse it and refile it in a number of different countries and allow and have a mechanism by which they can get the patent protection of the countries. So in what you're saying then is that avenue is now opened as of the signing of the bill in 2012 with respect to design patents, right?
Yes, and that should be a significant benefit to design patentees to be able to use one uniform application and file not only in the United States but also internationally.
Thanks, Pete, for your views on this. Companies interested in protecting the look and feel of their product should carefully consider acquiring design patents. It's clear that design patents can provide significant protection in addition to what utility patents provide, and it's clear that infringing design patents can create a significant risk. We hope that you found this podcast helpful in understanding some issues about protecting your intellectual property using design patents. Stay tuned for our next installment in Computer Magazine. Until next time, this is Brian Gaff
And Pete Cuomo.
Feel free to contact us via email at bgaff@edwardswildman.com
Or at pcuomo@edwardswildman.com.
Thank you.